So, Mr. Reader, the floor is yours.
Thank you, Your Honor. Good morning. May it please the court, Jack Ryder on behalf of Walmart. Your Honors, I'll reserve 5 minutes for rebuttal today.
Your Honors, and Mr. Ryder, I apologize. I know half the time I pronounce your name right, half the time I pronounce it wrong. So sorry about that.
No, I appreciate that, Your Honor, but no, of course, no problem. Your Honors, the trial court erred as a matter of law by allowing, first of all, plaintiff to call our medical causation expert, Dr. Cassidy, in plaintiff's case in chief, and then allowing the plaintiff to then elicit his examination through the use of leading questions, and then abused his discretion in the trial court in allowing plaintiff to present testimony from Ms. Thomas, who, as I'll discuss later in my argument, we believe was not presenting testimony based on a reliable methodology. But first of all, with respect to Dr. Cassidy and this issue, Your Honors, the interpretation of an evidentiary statute is a matter of law for de novo review, and the trial judge here misinterpreted and misapplied Rule 90.612, the evidentiary rule that talks about how leading questions are to be used. And they're to be used on direct examination only in certain circumstances, and only when a party calls a hostile witness an adverse party or a witness identified with an adverse party. And courts have historically discussed, and not now, there's no Florida case that's directly on this issue, but the cases that we've looked at from outside Florida, federal decisions and courts from other jurisdictions, have found that this notion of what it means to be aligned with a party for purposes of allowing an individual to call another side's witness, or in this case, an expert in the plaintiff's own case in chief, and then to elicit testimony using leading questions, it is inappropriate to determine, as the trial court did, that simply because Walmart hired Dr. Cassidy, that as a matter of law reflected an alignment of interests for purposes of this analysis. And here, Your Honors, courts that have described alignment talk about employees, friends, romantic partners, not expert witnesses. And the cases we've cited, for example, Suarez versus Ashford, out of the first six.
Let me interrupt and ask a question on this. At the trial, when the deposition was offered by the plaintiff, there was an objection as to leading and cumulative. And then there was some discussion back and forth about the rule and two different rules, one on use of depositions at trial. There was some discussion about whether the witness was adverse or hostile or affiliated as an interested party with the other side. At one point, plaintiff's counsel, well, let me go back. At one point, defense counsel says that they have to establish at the time the testimony is given that the witness is adverse to the plaintiff. And of course, the deposition was at a prior time. There wasn't any request by anybody to evaluate his testimony. But at trial, the plaintiff's counsel argued that if the court wanted, they could call up the entire deposition and go through it to show what areas the deposition reflects the witness was adverse or hostile to the plaintiff. The defense didn't respond to that and didn't say, yes, judge, you have to do that now. You've got to go through the deposition. We need to go through it and you'll see he is hostile or he's not hostile. Isn't that a problem for your position?
Your Honor, I disagree with that respectfully. I think if one looks at the transcript in its entirety, starting at around 1140 through 1160, the colloquy was extremely extensive. And trial defense counsel, I think, did an extraordinary job of articulating meticulously the standard, what the trial court had to evaluate, and the notion that the trial judge had a duty to do this as a matter of law. But I think what's most fundamental here, Your Honor, is the trial court's decision was based entirely on the fact that Walmart retained this expert. The trial judge never said, I'm going to evaluate this testimony and I'm going to examine it and I'm going to play it.
But the defense didn't ask the judge to do that.
But Your Honor, the defendant explicitly said, Your Honor, you cannot play this. The plaintiff cannot play this in his case in chief. And I think that's where, and the plaintiff really glosses over.
Let me ask it this way. Could the plaintiff call the witness or present the deposition in the case in chief, had there been a determination by the court by reviewing the transcript that yes, this witness is hostile or is interested and so forth?
No, Your Honor, he could not. And here's the reason why. And this is the part that the plaintiff never addresses. It is fundamentally improper for a plaintiff to call a defendant's expert in the plaintiff's own case in chief. This is one of the fundamental issues that the plaintiff never addresses. It's a multifactorial issue. Once the trial judge allowed the plaintiff to call our expert in their case in chief, what that does, and then to elicit that testimony using the leading questions, what that essentially did was it created a circumstance where the plaintiff was then allowed to use our expert to establish their burden of proof, even though theoretically we just could have decided never to have called our expert. In other words, the plaintiff had the burden of proving their case using their witnesses and their presentation of evidence. And we
how does that square with the trial court's observation about Rule 1.330, which says that a deposition of an expert can be offered or used by any party for any purpose if it's a witness that's an expert?
So the difference there, Your Honor, is that rule contemplates the notion where an expert's being called to testify and there's a use of an expert's testimony either to establish some to use it, whether it's for cross-examination purposes, for impeachment purposes, or to present a testimony, even in direct if, for example. And I think the difference is that here, the defendant, Walmart, had the opportunity. We had the right to elect not to call our expert. And I think one of the differences here, and there's abundant Florida law out of this district and others, which we've cited in our brief, like the Milburn case and other decisions, where it is improper to call another person's expert witness and to alert the jury that the other side retained that expert. And this is one of the issues that really highlights and illustrates. Did
Walmart ever take the position that in the trial court that the deposition would not be used during Walmart's case in chief?
We never had the opportunity, Your Honor. In other words,
during the argument to the trial court, Walmart did not say, Judge, we're not calling this expert. We're not using his deposition. They can't be allowed to use it because it's circumventing our ability to call or not call the witness.
And Your Honor, there's a reason why. Walmart could not have made that argument because that would have risked waiving the right to call the expert if they elected to do so. And that's the problem. The problem here is that the plaintiff bears the burden of proof. Plaintiff has to make a prima facie case. Walmart could have elected at the close of plaintiff's case to not put in any expert or any witness at all. But what happened here was, and then if Walmart had said at that moment, well, Judge, we just won't call, we'll withdraw this expert, then that creates the risk that Walmart will be precluded from utilizing the expert if they elect to do so, if, for example, the trial court denies a directed verdict. So to suggest that Walmart should have had to have abdicated the right to present an expert at that moment in order to stop the plaintiff from utilizing our expert in their case in chief and then utilizing leading questions and cross-examining him puts us in a completely unfair, untenable situation. It's a Hobson's choice. It would require Walmart to either surrender the use of their expert without knowing if the trial court might grant a directed verdict, or to allow, as here they unfortunately did, that Walmart made the argument extremely vigorously about this fundamental problem with allowing the plaintiff to call Dr. Cassidy in the plaintiff's case in chief, using Dr. Cassidy to create the plaintiff's burden or to meet the plaintiff's burden.
Can I interrupt for one question?
Yes, Judge.
Just one question. Was there a witness list exchanged by the parties prior to trial, and was Cassidy on Hindy's witness list?
Yes, Dr. Cassidy was a designated witness. He was.
So you were on notice that he could be called by the plaintiff as their witness.
That's where I disagree, Your Honor. The plaintiff does
What's
not.
What's the purpose of the witness list if not to put the other side on notice? He might be called as a witness.
He might be, but by the defendant. In other words, this goes back to this notion that Walmart has the right to decide whether to call its own expert. In other words, the plaintiff, if the plaintiff wants to call an expert witness, they have to either subpoena that expert or they have to hire that expert. The
But
plaintiff
you had a
did not-
deposition, for use at trial that was put together in this case, correct?
That is correct.
And you're saying even though he's on the witness list, they shouldn't be allowed to call him because it gave them an unfair advantage? Or is that a function of trial strategy that they had a better strategy under the circumstances of this case?
Your Honor, I don't think it's a matter of trial strategy. I think that it's fundamentally established that a witness, a party, cannot call another person's expert.
What's the best case you cite for that proposition?
So, Your Honor, we cite several cases, and the principle, let me just highlight those cases for the court. For example, Peterson versus Willie at the 11th Circuit, where it says, we believe a party should not generally be permitted to establish that the witness had been previously retained by the opposing party, unquote. And also, if we look at Lozano versus, and this is, the Lozano case is not a Florida case, but let me highlight the Lozano case. In Lozano, the court talked about this issue, and it said an independent medical expert is not an agent of the party who hired him for the purpose of obtaining his expert opinion. And it talks about that goes to the issue of the alignment. And here, furthermore, it is well settled that an expert witness may not be compelled to provide involuntary testimony pursuant to a subpoena. And that's the thing that I'm talking about here, Your Honor. The plaintiff could not have said, well, I'll just call your expert and I'll make your expert my expert, even though I didn't hire him, I didn't retain him, and even if I subpoenaed him, and because what that does is that would require an expert witness. It's not a fact witness, not a person who's interested in the outcome. That would require the expert witness to be compelled to provide testimony against his or her wishes. And in Lozano, the court talked about this issue very specifically. And it said, quote, even if defendants' experts had intended to voluntarily testify for defendants, the trial court's ruling did not merely allow defendants to call their witnesses out of turn, but rather required the witnesses to testify as part of plaintiff's own case in chief for the purpose of allowing plaintiff to attempt to satisfy his own burden of proof, unquote. Court found that to be erroneous and reversed, and the court there explained this principle, the notion that when you look at whether or not an expert is aligned with a party for purposes of allowing that person to be called, the court said no. The court said the case law on this issue has repeatedly said that an expert is not ipso facto aligned with a party unless and until there's an established.
The trial court in this case didn't establish a categorical rule saying that, did they?
The trial judge said categorically, the trial judge did enunciate that because Walmart retained Dr. Cassidy, he was aligned with us. Yes, the judge made that finding.
So you're saying it's either an abuse of discretion or an error of law?
One or the other, for sure. But I think it's an error of law because of the misapplication of 90.612 as an evidentiary rule, which is a de novo standard, because it fundamentally goes to the interpretation of what it means to be aligned with a party. That's where the trial judge erred as a matter of law, because he concluded that the alignment was established because Walmart hired Dr. Cassidy. And that was the start and stop of the trial court's analysis. And respectfully, that is simply incorrect. We've cited Wadham versus Bank of America. Expert witnesses are not customarily considered witnesses identified with an adverse party. LaSalle Bank versus Massachusetts Bay Insurance Company, where again, in the sense of what constitutes alignment, expert witnesses are not considered to be aligned for purposes of this analysis. And we hear this, I'd highlight the fact that the burden is on the plaintiff to demonstrate that this was not harmful under Special versus West Boca. And we know this was harmful. And how do we know? Because when the plaintiff capitalized upon this, the plaintiff's counsel, he talked about the fact that Dr. Cassidy was such a great witness that he made him his own. He said as follows, he said, the great Dr. Cassidy, this is the gentleman who appeared yesterday. He was the last witness appeared by video. He was a good doctor. He provides opinions only for defense lawyers, and he provides opinions only for companies who are being sued. I saw some of you perk up when you heard my voice when it was being done by video. Like, wait a minute, I thought these guys were calling this witness. That's plaintiff's counsel's voice examining this guy. A couple of you actually looked up and said, and looked over to the table. Wait a minute, I thought this was plaintiff's witness. No, this guy was hired by the defense to provide them with testimony to help avoid having to pay. But we were so pleased with his testimony, he became our witness. So the plaintiff's counsel, not only did the plaintiff's counsel succeed in doing what he attempted to do, he was allowed to call Dr. Cassidy in his own case in chief over our objection. He was allowed to elicit testimony improperly by using leading questions. And then he acknowledged that not only was Dr. Cassidy not aligned with Walmart, plaintiff touted the fact that Dr. Cassidy was so good that, quote, he became our witness, unquote. That's at page of the transcript, 1557 and 1558. And I would submit that to me, that really emphasizes the fact that this constitutes the kind of harmful error that exemplifies the reason why the rule should be applied here in Florida, just like other cases have found.
Counsel, you've gone through the 15 minutes. If you wish to reserve the rest for rebuttal, or you can proceed if you choose.
Thank you, Your Honor. Just to round out, we've also argued that it was improper to allow Ms. Thomas to testify as set forth in the brief, and I'll just summarize these points. We've identified how she never visited the store where the accident happened, didn't know the dimensions of the floor mats or warning cones, was unfamiliar with a litany of factors upon which she based her testimony, number one. And number two, we believe the trial court abused his discretion in allowing Ms. Thomas to simply talk and describe what she saw in the video. So for those reasons, I'll reserve the rest of my time for rebuttal unless there are any questions about that specifically. But as a matter of law, as to the first issue, we believe this clearly constitutes grounds for reversal and remand for a new trial. With that, Your Honor, I'll reserve the rest of my time. Thank you.
Very good. You'll have 4 minutes for rebuttal. Mr. Caldevilla.
May it please the court. Good morning, Your Honors. I'm Dave Caldevilla. I represent Mr. Al Hindi, who is the plaintiff in the trial court proceedings. The trial court did not abuse its discretion or commit any error by allowing the plaintiff to present Dr. Cassidy's video deposition. Plaintiff's counsel presented Dr. Cassidy's entire video deposition, including Walmart's entire direct and redirect examination. This is the same video that Walmart itself was going to present during its own case in chief. So regardless of whether the plaintiff presented the video or Walmart presented the video, the jury was going to see and hear the same video. Now we're hearing today for the first time that Walmart may not have wanted to present Dr. Cassidy.
But how do you know Walmart was going to present that video deposition regardless?
Well, they're on the witness list, and counsel never said.
You're assuming they would have done that. You're assuming they would have presented Dr. Cassidy.
I'm assuming that, Judge, because he was their star witness, and he was on their witness list, and they didn't say, you know what, we're not planning on calling Dr. Cassidy after all. All these arguments today about how they were prejudiced in their strategy as to whether or not the plaintiff was going to meet their burden of proof, and none of that's in the brief, none of that's in the record. This is the first time I'm hearing any of that. So this is
the other question is, it seems like this is an abuse of discretion, and that's the standard on appeal, but he's arguing it's also an error of law by the trial court to let the video deposition in your case in chief.
Yeah, it's neither, Judge. It's not an abuse of discretion. It's not a situation where no reasonable judge would ever agree with what our trial judge did. In fact, I think there's 3 federal decisions that we've cited. You know, there's no Florida case interpreting this statute, all right? So we looked at federal cases, and counsel cited some state law cases from Michigan and I think Nevada, but I think the federal cases go my way. There's a First Circuit decision, a Fifth Circuit decision, both of which in those cases said, yeah, the expert is aligned with that party, and sure, you should be able to call him in your case in chief and lead him. That's the National Railroad Corporation case and the Perkins versus Volkswagen case. There's also a federal district court case from Pennsylvania, Leskin versus Pottsville, that we cite. But you know, none of these cases are controlling. We know that. They're persuasive, I guess. But you know, what we do have in Florida is the Florida Supreme Court says that, look, when you look at a statute, we're going to look at the plain text, and we're going to apply the plain text. So if you look at the plain text, there's no error. and there's certainly no abuse of discretion. The statute, which is 90.612 subsection 3, it does not state that leading questions cannot be used during a party's case in chief. What it says is leading questions should not be used on direct examination, but should be permitted on cross-examination. In this case, all the leading questions by plaintiff's counsel were asked during cross-examination after the jury had already heard Walmart's complete direct examination of Dr. Cassidy. And if you review the cross-examination of Dr. Cassidy, you're going to see that he frequently provided thorough explanatory answers to the leading questions. He was not boxed in or restrained in any way. He had full reign to give his answers fully and completely. So this was yes, he was asked leading questions, but we never hear anything also about, oh, well, his answers were inaccurate or he was misled by these questions. There's none of that, and none of the testimony itself was inadmissible, despite whether or not the question itself was leading. And there's many federal cases that we cite in our briefs where that's a key factor to consider. Okay, the witness was asked the leading question, but was the testimony inaccurate? There's no proof of that, and of course it wasn't. You can read the transcript. You can also see that Dr. Cassidy, now we don't have the video, so we can't hear the inflections of his voice and his posture and the way he was conducting himself. We can't see or hear that because Walmart hasn't put that video in the record. But if you read that transcript and you read in the light most favorable to Mr. Al-Hindi as the appellee, you'll see that he was pretty outspoken. He was, I think you could say that he was hostile. He told Mr. Gordon, trial counsel, he said he was trying to mislead the jury. He said that twice on the record in response to questions. If that's not hostile, I don't know what you would call that. And I think, it's a natural, it's only natural for the trial judge to say that an expert witness is somebody identified with an adverse party. Experts are typically biased in favor of the party that retains them. I don't think that's a surprise argument here. I think everybody knows that. The Fourth DCA has held in a case that we cite, the Katzman versus Red Iron fabrication case, that experts may be biased in favor of the retaining party because he or she has a financial incentive. We all know this. Now, all the arguments that we've heard in response to Judge Silberman's questions, I think also are wrong. The rule 1.330 clearly says that if there's a deposition taken of a skilled or expert witness, that's fair game for any party to present in their case in chief, as long as it's admissible. And we contend it was admissible. Judge Valenti, in response to your question to counsel, Dr. Cassidy was on both witness lists. Okay, he was on the Walmart's witness list, and our witness list had a catch-all provision that said any witness listed on your list is our witness too. So there's no surprise about this. In fact, Walmart, if there was any prejudice from Dr. Cassidy's testimony, nothing prevented Walmart from going ahead and calling him as their own witness during their case in chief to say, let's clarify, you testified on cross-examination in this video, X, Y, and Z. Let's talk about that. They didn't do that. Now, if you compare that with Dr. Foley, who was the last witness we called, the plaintiffs called, Dr. Foley was another Walmart witness. Their expert witness. We called them in our case in chief through the deposition. Once again, that was a non-video, but we read portions of the deposition into the record. And yes, there were leading questions. No objections from Walmart about that. And then what happened? We rested our case. What did Walmart do? The first witness they called was Dr. Foley. Well, why didn't they do that with Dr. Cassidy? They waived it. And we're hearing arguments today about how this was used to our advantage in closing argument, how we said that we made him our expert. That didn't prompt one objection from Walmart. They did not object to the closing argument. They never said, we want an instruction that they can't say that he was our witness and they made him our witness. None of that is in the record. These arguments are not preserved for appeal, Your Honors. I know counsel hardly got a chance to talk about Ms. Thomas's testimony, but there is no error or abuse of discretion there either. Their arguments, their Daubert arguments, they're not even preserved for appeal. Now, at the Daubert hearing, the trial judge said, okay, I'm going to grant this, I'm going to deny Walmart's motion to exclude this witness, but, and I'll be specific, he said, quote, that ruling, he says, quote, is still subject to objections which can be raised as to particular testimony and opinions she gives. And at trial, Walmart can raise objections to particular opinions that she gives and don't appear at trial to be based on sufficient facts or data or principles, which is the Daubert standard. Basically, the judge is saying, I'm denying your motion without prejudice. Feel free to object at trial and I'll consider your objections. And if you read the trial transcript, you'll see that this trial judge was very open-minded about ruling on objections. He sustained one of the few objections they raised. This judge actually sustained their objections. So there was no reason for Walmart not to object if they felt like this evidence did not satisfy statute section 90.702 or the Daubert test. Now, really what they're arguing about goes to the credibility and weight of the opinions and not to the admissibility of the opinions. I think that's crystal clear. But that's if assuming that the arguments are preserved for appeal, which they're not. Now, counsel has said that today, you know, he's concerned, I think, about the narration. I know he quickly touched on Ms. Thomas's testimony, but he was complaining that she was allowed to narrate the video. Now, what trial have Your Honors ever attended or read a trial transcript involving an exhibit that witnesses weren't permitted to talk about what was going on in that exhibit? In a breach of contract case, we get an exhibit, it's a contract, the witnesses are testifying what's in the contract, what's not in the contract, how they breached it, how they didn't breach it. When there's a video, I've never seen a trial involving a video where the video is not stopped and the witness saying, what happened right there? That happens all the time with every type of exhibit, not just a video. And counsel has not cited any cases that say that a witness is not allowed to comment on exhibits. And again, there weren't any objections to these types of questions and answers. In fact, Walmart itself, if you read Walmart's cross-examination of Ms. Thomas, you'll see that Walmart put up the video and stopped the video and said, let me ask you about what's happening right here in the video, Ms. Thomas. She did it. In fact, almost every single witness in this trial testified about the video, including Dr. Cassidy. Dr. Cassidy testified about the video. He said, I saw the video, and after Mr. Al-Hindi slipped, he sort of got a weird gait. I forget his exact testimony, but he was talking about the way his leg was dragging or something, which led him to believe that he had a pre-existing injury. So again, almost every single witness testified about the video. So I don't see how that's a viable reason to reverse this case. Her testimony was based on sufficient facts and data. And at the bottom line, her testimony was based on sufficient facts and data. It was based on a 2 hours worth of video that Walmart itself records for the very purpose of what it's being used for as evidence at trial. That's why Walmart takes these videos, so everybody can see exactly what happened. She relied on that. She relied on photographs. She relied on Walmart's own written policies, which are in evidence, and she relied on industry standards, which she has 20 years of experience to apply those. And that satisfies the Daubert test, which is a very flexible and liberal standard, which all the courts have recognized is more liberal than the Frye standard. And the trial court has broad discretion in applying that. And the test is not whether really the judge erred. The test is whether or not the judge followed the standards required by Daubert in section 90.702. And this judge followed them to a T. And so really what we have is just Walmart arguing about the weight and credibility and not the admissibility. Unless your honors have any other questions, I'm just going to ask you to affirm based on.
Calvia, I have one question under Rule 1.330, because there's been some discussion in the briefs and today about some of the federal cases. My recollection is the federal rule is not worded in the same way as the rule of civil procedure, Florida's rule of civil procedure regarding using the deposition for any purpose with the language as far as an expert. Did I miss something in the federal rule, or are they in fact written differently?
So Judge, I know that you are right about that. Because I too have noticed inconsistencies between that rule and the Florida rule over the 35 years of my practice. Did I bone up for that today for this oral argument? No, I did not. So I do know there are some differences, whether they are in play today. I really don't feel comfortable saying that, but I know that Your Honor will go back and check that. So,
very good. Thank you, Mr. Calvia.
All right. Thank you, Your Honor.
Mr. Ryder.
Thank you, Your Honor. I'll start by just reiterating the fact that the standard of review here is a de novo standard. And I think that the court should be critically focused on the point that this is a matter of interpretation of 90.612. With respect to the issue of the use of depositions, Your Honor, Judge Silberman, as you just asked counsel, with respect to the issue, I'm not aware of a distinction that would, and again, I'll echo a little bit of what Mr. Calvia said, in the idea that this was not something that was specifically addressed by plaintiff in their brief. They didn't talk about differences between the rule, but here's the part that I would say. 90.612 is an evidentiary rule that talks about the use of depositions. Uses of depositions is under 1.330, but the evidentiary rule, which talks about whether or not a certain form and presentation of testimony can be provided, still must be applied if we're going to read this in para materia. And it's not about the use of the deposition. And I want to make this very clear. This is not an argument that the deposition could not have been used. The argument is that it's the manner and form of presentation under 90.612, which explicitly says that you cannot use leading questions in your own direct unless you establish that a witness is aligned with the adverse party. That's the harm.
What's interesting here, though, and I appreciate the argument, but this was not, in terms of the deposition, the plaintiff's witness that he was leading. This was the defense witness. The defense examined the witness. Plaintiff cross-examined, and it's appropriate to use leading questions by cross-examination. And so that's why I'm so troubled by the language, or not troubled, but I'm focusing on the language of the rule, which says that, you know, the deposition of a witness, whether or not a party may be used and so forth, if the witness is an expert or skilled witness. And so I'm trying to reconcile those two.
And to be clear, I'll start by saying that every case that we cited, Your Honor, that talked about an expert witness, where that said that an expert is not automatically aligned with the adverse party, there was cross-examination there too. That what turns it from cross-examination and appropriate leading to direct examination and improper leading is the fact that the plaintiff was allowed to put it in during their case in chief. Once the plaintiff played it in their case in chief, it transformed the inquiry from a cross-examination to a direct examination as a matter of law. Because it goes back to what I said before, as Judge Vellante asked counsel, they're all assuming that we were going to play Dr. Cassidy. And I do want to make another point. At the record at 615, and counsel did observe this, they didn't specifically list Dr. Cassidy. They didn't say, we intend to use this as our expert. They said, they had a catch-all. They said, any other witness that was listed on the defendant's witness list. Now, I know that that's sort of a common practice among attorneys, But to be clear, to suggest that their catch-all saying that we might call somebody on Walmart's list, that in and of itself somehow converted Dr. Cassidy to their expert is fundamentally improper. So Judge Silberman, the idea is it's not about whether or not they could have used the deposition. It's not about whether or not they could have led Dr. Cassidy. It's about using it in a manner that turned it into a direct that they acknowledged was so good that, quote, he became our witness, unquote. And I do want to emphasize the notion that there's no reason to object to a closing statement that once the court had already made a definitive ruling. The damage, the harm was done once Dr. Cassidy was turned into their witness by utilizing cross-examination questions in the form of leading questions during their case in chief. That's the harm. That's what violates these cases that we've cited. That's what flies in the face of 90.612. And we both sides agree. There's no Florida case that explicitly addresses this, but the cases.
Mr. Reiger, you've got about 15 seconds to wrap up.
So in my 15 seconds, I would ask the court to note that the cases cited by plaintiff, those federal cases, Leskin, National, Passenger, and Perkins, all of those, in each one of those cases, the plaintiff first established that the expert was objectively hostile before he was allowed to cross-examine. Your Honors, I respectfully request that this court reverse and remand for a new trial. Thank you.
Very good. Thank you both very much. You may exit the courtroom. And the next case is Dooley versus Trubinsky.